I now call the meeting to order. Welcome to the 40th meeting of the House of Commons Standing Committee on Public Safety and National Security, pursuant to the House Order of April 20th, 2026, and the motion adopted by the committee on April 30th, 2026. The committee is meeting as part of its study on Bill C-22, the Legal Access Act. I would now like to welcome our witnesses. Yes, our three witnesses. From the Canadian Bar Association, Madam Christiane Saad. Second, from the Canadian Constitution Foundation, Alexandra Surgener. And third, from Open Media, Mr. Afir Hatfield, who is here with us virtually. You're all welcome. You each have 5 minutes for your opening remarks, starting with you, Madam Saad. Thank you very much, Mr. Chair.
Thank you for the opportunity to appear today on behalf of the Canadian Bar Association as chair of the Privacy and Access to Information Law section, which with the Criminal Justice section and the Anti-Corruption team have studied C-22. We acknowledge the improvements to the bill from earlier versions, but significant concerns remain. The CBA notes 4 critical gaps, but let me begin with the structure. Bill C-22 bundles 2 different regimes under one banner. These deserve to be debated as separate bills, so neither escapes proper scrutiny. First gap, the absence of evidence of necessity. When government expands its power into private lives, the burden is on it to show that the expansion is necessary. The government has not demonstrated that current laws hinder investigations. Both CSIS and the Criminal Code already provide for assistance orders with judicial oversight for technical capabilities. Without evidence that these tools are insufficient, expanding powers is premature. In addition, 3 of the 5 IS countries mentioned have no constitutional protection against unreasonable searches and seizures. Canada does, and so Section 8 of the Charter must remain front of mind. Second, Bill C-22 dramatically expands lawful access powers. More parties could demand access, more information could be compelled. Technical capacity requirement would be broadened and more entities would be subject to it, while judicial discretion would be reduced. This expansion has lacked adequate consultation with key stakeholders for feasibility, impact, and proportionality. Third, the lack of safeguards. For Part 1, the bill creates the new subscriber information production order on the lowest threshold our legal system recognizes. Mere reasonable suspicion. Yet, this order compels all subscriber information a provider holds, potentially reaching what the Supreme Court calls biographical core. That definition should be narrowed to information that simply identifies a subscriber. We are equally troubled by the voluntary disclosure provision, which appear misaligned with the court's ruling in Spencer and Bykowitz, and by non-disclosure order that can last for a full year. The CBA recommends reducing this to 90 days with court approval required for extensions. The new confirmation service demand power allow a peace officer to demand confirmation without judicial authorization and mandates 24 hours response time. This timeline is unrealistic, especially for smaller providers, and CBA recommend extending it to 48 or 72 hours except in genuine emergencies. Part 2, which concerns us the most, this new act would require ESPs to build capacity for lawful access, which in plain terms would mean building backdoors. These access points become magnets for hackers. Examples from other jurisdictions show that the equivalent law created vulnerabilities for foreign actors exploited to steal data. And the issue of metadata is even more critical. Although one section imposes some limits on the nature of the data retained, but it is well known that the metadata includes sensitive information, and in this context, it can also include location data. Beyond that, Part 2 effectively deputizes companies as surveillance arms for the state while shifting investigative costs to private sector without compensation and without judicial overview. So the CBA recommends that these ministerial orders be removed, that the definition of systemic vulnerability be strengthened to expressly protect encryption, and that the government bear costs and risk related to these. So overall, the CBA sections believe that Bill C-22 risks violating Section 8 of the Charter. The CBA is not opposed to supporting law enforcement. The CBA opposes expanding state surveillance powers without evidence of necessity, without adequate safeguards, and with insufficient judicial oversight. Further details are in our written submission. Thank you for your consideration.
Merci, Madame Saad.
Thank you. Now, Mr. Alexander Surgener, 5 minutes, please.
Good afternoon, Mr. Chair. My name is Alexander Surgener, and I'm counsel with the Canadian Constitution Foundation. We are a nonpartisan, donor-funded legal charity, and our work consists of education and advocacy on matters pertaining to civil liberties, the rule of law, and our constitutional order more generally. This is my first time appearing, so thank you for the invitation. Our concern with this bill is longstanding, and it dates back to really the progenitor bill, Bill C-2. And while we're pleased with the evolution there and the modest amendments and changes that followed, we remain concerned, even more concerned, in fact, about Bill C-22, and that's why I'm here. The concern really is this, and I don't mean to be hyperbolic, but truly it's difficult to escape the inference that Bill C-22 would establish a pretty powerful regime of surveillance and would constitute a pretty severe invasion into the privacy of everyday Canadians. Our concerns fundamentally are about the intrusiveness, the vulnerability, and the overall secrecy that this bill envisions. So allow me to identify exactly what I understand this bill requires. So-called core providers may be ordered to develop, test, and maintain technical capabilities for extracting information, and in particular computer data. I'll get to that in a moment. This would be achieved in part by installing, using, and maintaining a prolonged and continued access, perhaps, to any given device. Now, the concern here, of course, is that it's not just so-called core providers. It's the fact that electronic service providers, which is an enormously, which carries with it an enormously broad definition, could, following a ministerial order, also be required to undertake those same acts that the so-called core providers are. So very quickly, an electronic service provider, and I'll define that in about 5 seconds, could also become a core, a core provider. So again, there's no reassurance that to be had in really defining those two terms differently. They're one and the same, and would be quite quickly. Now, what is an electronic service provider? It is any entity that provides business in this country or conducts a portion of its business in this country through electronic channels, be it through the internet or through perhaps software that's installed and kept locally on a device. So internet connectivity is relevant in that case. Now, at heart here, and this is really the pith of this, is the concern about metadata. Metadata is information about information. And so while the context of a text message might not be accessible, the fact that a text message, as an example, was sent could be accessed. To whom, when, how, all of that is fair game. The fact that a phone was used on the Hill in Ottawa and then 2 days later is in a library in Corner Brook and another day later finds itself in a hotel room in Saskatoon, all of that's fair game. We can, with this bill, monitor that, keep track of that, follow that. In other words, the entirely innocuous and inherently private comings and goings of ordinary citizens is up for grabs. Up to a year's worth of movement, communication, work, and ordinary life would be preserved for review, while the private citizen, of course, is kept completely oblivious as to this occurring or not. And though the bill says that no such order would be made if it would introduce a systemic vulnerability, I'm not particularly sanguine about that. the notion that only the that only the good guys will have access to this flies in the face of examples from our peer nations in the Five Eyes who have suffered data breaches of exactly the sort that would constitute a systemic vulnerability. If the aim is to better investigate criminal activity, and I have some knowledge of this having worked as a criminal defense lawyer, so I've seen both sides of this, it's unclear to me why the proposed powers have to be so broad so as to capture basically every device in this country. The CCF would gently remind everyone of the terms public official and private citizen and the key distinction there. The importance of privacy cannot be overstated. Privacy is about dignity and autonomy, and these are the predicates of a free society. To have a truly free society, we must be free to make our choices without the sense of being monitored, and of course not even knowing that we're being monitored. I see that I'm at time, so once again I thank you for hearing our concerns and inviting me to participate in this critically important discussion.
Merci, Monsieur Surgener.
Thank you. And now, Mr. Hatfield from Open Media. You can speak. Go ahead.
I'm Matt Hatfield. I'm Executive Director of Open Media, a grassroots community of 230,000 people in Canada that work together for an open, accessible, and surveillance-free internet. I'm joining you from the unceded land of the Sayet on Salt Spring Island in BC. Do not let the Public Safety Minister convince you that limited amendments will fix C-22. They will not. Nothing short of striking the majority of Part 2 will protect Canadian privacy. Government's current approach is an enormous own goal against our economy and our security, and you are the only people who can stop it. I won't repeat the facts you've heard from Professors Diab, Geist, Apple, Meta, and others. I'll use my time to explain why light amendments cannot do the job of making this bill safe. In recent weeks, the minister has said the government will amend C-22 to bring it in line with our allies' lawful access, like America's CALEA. So let's compare. C-22 can require telecom companies, online services, and even hardware manufacturers to let the government install surveillance equipment on their platforms, and to retain a year of metadata on every person in Canada. That isn't catching us up to CALEA. The two aren't even in the same league. CALEA covers only telecom companies and requires no metadata retention, nothing approaching a year's data on everyone by default. Of the Five Eyes, only Australia mandates metadata retention, and there it's deeply controversial and being reformed. And I think we need to bear in mind, taking a step back, in this threat environment that we're entering, CALEA is not a success. CALEA has been in effect since the 1990s, but in recent years, the backdoors required by CALEA are increasingly a key entry point for foreign hackers to compromise US privacy. In 2024, Chinese state actors used it to compromise the systems of America's largest telecoms, affecting more than 1 million people. Just this February, the FBI found CALEA's backdoors had led to the breaches in their systems and reported it to Congress as a major security failure. We aren't catching up to a working global standard here. We're leapfrogging well beyond what any of our allies have done, creating a more vulnerable version of a system that's failing other governments. And what about the minister's promise that selective amendments can fix the bill? The security and legal experts you've heard from have been clear. This bill will not protect encryption in any way that matters. The government's promise is to provide a narrow technical protection, that C-22 won't force a company to break encryption. But breaking encryption as a standard and defeating it are not the same thing. A working lock is no protection if you're required by law to leave the door open. C-22's capability orders can compel a provider to build and access to information before it's encrypted or while it's temporarily decrypted, at the device level, within software, or as data is being handled. None of that breaks encryption as a standard. All of it circumvents the protection encryption is supposed to provide. That's a foundational problem of C-22, not a simple definitional problem to fix. In fact, this bill as written makes sure that none of its definitions can actually protect Canadian rights. Much is made of the difference between an electronic service provider and a core electronic service provider, with the strongest default obligations on core providers, although the government, of course, will decide who a core provider is later by regulation. But Section 7.1 lets the minister impose any obligation that a core provider faces on any service provider. Because these orders have no gazetting requirement, counterintuitively, every invasive requirement a core provider faces can be applied to any provider with less public scrutiny. In that same logic, maximal flexibility, ineffective by design safeguards, governs the definition of systemic vulnerability. That definition today isn't good enough, but even a strengthened good faith version won't fix C-22, because Section 47(1)(c) explicitly grants Cabinet the regulatory power to reinterpret any term in the bill. As the case for Bill C-22 has crumbled, the minister has claimed that opposition is driven by foreign big tech firms attacking Canadian sovereignty. That's plainly not true. Canadian tech success stories like Winscribe and Shopify have rallied against this broken bill as strongly as anyone. Open Media's community has sent nearly 25,000 messages to MPs opposing C-22 and Bill C-2 before it, and helped rally more than 300 organizations against C-2's privacy provisions. We don't take a dollar from big tech. Our budget comes from small donations from ordinary Canadians. The truth is that big tech firms were late to this conversation, and it was ordinary Canadians who sounded the alarm from day one. Now, the minister has said the government wants to have a filing cabinet of every Canadian's metadata ready for law enforcement when they need it. To that, I say democracies do not keep a filing cabinet of every citizen's sensitive information in case it's useful to spies or police. This process has been pushed so quickly the system is not keeping up. We submitted our brief more than 2 weeks ago, on May 15th, yet due to the sheer volume of input you've received, I learned today committee members have not yet received it. This is a symptom of a rushed, under-researched process for a bill that has massive stakes. On behalf of our community, I urge you to take the time to receive and review all public evidence and thoroughly reform or abandon Part 2 of C-22 before it moves forward. Thank you, and I look forward to your questions.
Thank you, Mr. Hatfield. Let's turn to
Point of information.
MP Caputo.
Point of information. Mrs. Sahad has alluded that there was a memoir that was presented. It may be my mistake, but I can't find it. So you have it, okay, from the binder.
Est-ce que ça vient de Madame Saad?
From the binder.
It's available. We got it in. Oh, my apologies.
Barreau du Canada, hein?
From the Canadian Bar Association? Oh. We submitted it last week in French and in English. Oh, it must be the translation delay. It was submitted in French and in English. In French and in English. There are too many mics open, and I can't speak. Thank you. What I'm hearing is that the French and English versions were submitted from the Canadian Bar Association, but the House's translation team must validate both versions, and the validation is still underway. That said, MP Caputo for 6 minutes.
Okay, sorry, I'm going to speak about this in my time because I think it's very important to speak about it. Mr. Hatfield, I thought I was going to ask questions about Section 8 and search and seizure and de facto seizures, but just so I'm clear, Mr. Chair, is the policy that when a brief is submitted, translation has to review it even though it is translated already? Do I have that right? Okay. But in the interim, prior to translation, can it not be disseminated and then the translated version, the authenticated version? So are we, like, I'm trying to choose my words carefully, and I'm not trying to cast aspersions or blame, but if a brief was submitted 2 weeks ago by Open Media, I guess I'm asking what was the delay from 2 weeks ago to now?
Well, exceptionally, I can ask the clerk to provide guidance as to what happened.
With regard to Open Media, we received their brief, and like a lot of others that we have received, it is in translation. As I explained to Mr. Hatfield earlier today, we are dealing with a large number of documents that have been submitted, and we are not the only committee that unfortunately are drawing on translation resources. This has caused longer than expected or anticipated delays, which, though unfortunate, is not something that is in the purview of the committee to actually deal with at this time. With regard to documents submitted in French and English, it is a rule of the committee, established by the committee, that any document submitted that doesn't come from an MP's office or from a department or from the House of Commons, if it's submitted in both official languages, it has to be sent for linguistic review to the Translation Bureau. and then we fall back into the same issue that the Translation Bureau has an enormous amount of work to do, which is causing longer than anticipated delays. Thank you.
And how many, when are amendments due?
They were due yesterday.
Okay, so I guess I'm a bit concerned here because, you know, we don't actually know we don't know what we don't know as committee members. And by that I mean, I don't know how many briefs are outstanding. And we have submitted our amendments. I mean, obviously, that's on behalf of the Conservative Party. I have to ensure that His Majesty's loyal opposition is properly represented. We know of at least 2 that are outstanding, and we wouldn't know about this were we not having this meeting. It seems to me that the appropriate remedy is that we should be reopening the deadline for amendments, because I can only state that you know, I'm not going to give away our work product as a lawyer, but I will say that my staff, who's done an excellent job, do go through these briefs. They do review them, and they do look at amendments, and they do cross-reference them to the point where I'm not telling tales out of school. There are 70 amendments that we've looked at. Mr. Chair, this is a problem, and I'm not sure how we deal with it with the greatest of respect, and I'm not trying to throw anybody under the bus, because if there's not enough resources for translation and the government wants to have its legislative agenda passed, we can't exactly have your cake and eat it too by saying, get this done, but we're not going to allocate the resources to get the translation done. So what I would ask, and I will resume my 6 minutes if there's anything left, I'm not sure if the clerk can tell us what briefs are currently in that translation line, if you will. Does that make sense? As in, what don't we have that has been submitted?
Well, let me summarize in 3 different points. First, as we know by experience, the submission of briefs is a continuous process. So there were briefs several weeks ago. There have been briefs submitted a few days ago, and I suspect there could be briefs submitted today. So there will be briefs and views submitted over a continuous time period. The second thing is that the Translation Bureau, as the clerk mentioned earlier, proceeds in terms of priority, does the work most professionally, and does what it can to assist the members of this committee. And the third thing is that we have already committed to an agenda. Today is the last day for witnesses, and we have decided that we would be moving to clause-by-clause work on Thursday. And as we know, between now and Thursday, there will be more work ongoing. So having said that, I'm going to see whether I think there is more time for you, Mr. Caputo, to keep intervening.
I have to register for the record, Mr. Chair, that we still don't know what briefs are outstanding. And what I would like, and I would hope that all colleagues around the table would say, before we move to clause by clause, heck, amendments were already due. We know of 2 briefs right now that we haven't seen yet. I guess my question is, are there more? I think that the committee has a right to know that.
There are possibly more, MP Caputo, but unfortunately, at some point, we have to stop hearing witnesses and considering additional briefs. Otherwise, this process is going never to end.
Well, with the greatest of respect, Mr. Chair, I would agree with you if the brief came in yesterday or the day before or even Friday. Although, if it came in on Friday, these are briefs that came in 2 weeks ago. So, yes, we do have to draw a line. The question is when should that line be drawn? If a brief is submitted well in advance of the period at which we are considering amendments, I think we are bordering on a privilege issue even then. 2 weeks, I would shudder to think that anybody around this table thinks that this is Parliament, for goodness sakes, right? We shouldn't be waiting 2 weeks without even knowing that something is there. I mean, it doesn't feel right, to be very candid, that briefs are sitting in the queue and that we don't know that they're sitting in the queue and that we're putting forward amendments. I mean, the only alternative is then to table drop amendments after the fact. So perhaps I'll have something more official to say. I'm just speaking out loud here. And the fact I'm not getting point of order speaks volumes, although I might have one now.
Non, écoutez, la Chambre des communes, comme n'importe quelle autre.
No, listen, like any other organization, we have limited resources. All committees are dealing with the same issues, the same constraints. This committee is no exception. We are working with the resources allocated to us. That is why time is also a limited resource. You have 1 minute left for Mr. Caputo, if you would like to continue.
Let's talk about what we do know. Ms. Saad, I'm a law nerd, full disclosure. You spoke about Section 8 of the Charter being engaged. My reading of the bill is that the requirement for data retention is on the third party, as in those who are covered by the bill, and that a warrant is then required to access the data. Can you connect the dots for me, please? And I'll ask your colleague as well to do this in terms of if a warrant is required, which I believe prima facie the search is legal, if a warrant is required. Can you connect the dots on a charter breach just to help us out there? Am I making any sense here?
So our analysis for the charter part is that by retaining all this data and the metadata eventually for such a long time, we have so much information retained on people. And this is the link where it seems that so the fact that we are requiring so much subscriber information, and not just who is the subscriber, may include in this breach to the charter, because it's way beyond the reasonable suspicion that usually is required.
Okay, so it's the volume of the data.
The volume of the data, and the type of data as well.
It's the fact the government is compelling that data to be kept. I don't want to put words in your mouth.
And the
I just want to
type
make sure.
of data as well is problematic in this case as well.
Mr. Surgeon, or I hope I pronounced your name correctly, do you share that?
Unfortunately, MP Caputo, that's all the time we have for now, but there might be an opportunity to get back to you shortly. Madame de Dandurand, pour 6 minutes, s'il vous plaît.
Madame Dandurand, thank you very much, Mr. Chair. And I would like to highlight the point from my colleague across the way. We talked about time that is limited. There are many motions adopted that said we would go to clause by clause, and we added a day to hear from more witnesses. We had enough time to table amendments, and I do think it's important to respect the wish of the committee to undertake the study as planned and as agreed upon since the last meetings, and for us to finally go to clause-by-clause consideration as we agreed upon. So thank you, Mr. Chair. But I would like to highlight the fact that we have other things to do in committee, and we must move forward. So thank you. And starting now, I will address my questions to the witnesses. Thank you for being here with us. I have a question for both the Canadian Constitution Foundation and for open media. We've heard quite a lot about your worries regarding this act. I'd like to really get back to the very beginning, the goal, the underlying goal of the act. With those two witnesses, do we at least agree on one thing, the fact that police are dealing with real issues linked to encrypting in their investigations on sexual exploitation of children, organized crime, and terrorism? Can we at least agree upon that, sir?
Thank you, Madame Dandurand. I lament having discontinued my French after high school, although it was my best subject, but I'm certainly very rusty. I don't think anybody would deny that there are very serious complications in an ever-connected world. That goes without saying. And again, I think I do bring a unique perspective, having actually represented individuals charged with those very crimes. And I'm not celebrating the fact that those crimes occurred. Of course not. But what I am hoping to point out is that, as my colleague Ms. Saad had alluded to, I would agree that there exist adequate means already to investigate crime. I've seen it. I've reviewed the disclosure in court. I've run trials and reviewed and lost trials because the evidence was robust enough and the police were clearly able to do what it is they needed to do. Granted, there are lamentably more out there and they need to be investigated. But the concern, of course, is really with the scope and the breadth of the search. No one present here today would ever suggest that we need to curtail what already exists. It's more a question of limiting the half-conscious expansion of power and the inflation of the authority where there doesn't necessarily need, or excuse me, where there hasn't been, I think, compelling evidence to suggest that that's imminently and eminently required at this time. I hope I've answered your question in not too roundabout a way.
Non, j'aimerais poser la même question à Monsieur.
Not at all. I'd like to ask Mr. Hatfield the same question.
We do not put cameras and microphones in the home of every Canadian, even though that would be useful for investigating many serious crimes. This bill is doing a version of that, certainly on the metadata and arguably on other data as well, to every online service. And so, yes, there are serious crimes that you're mentioning. A version of Part 1 could be useful to the police in investigating that, but Part 2 is well beyond that and way out of line.
Alors, à vous deux, est-ce que vous pensez que c'est possible?
Question for both of you. Would it be possible to have a legal access regime that is modernized while maintaining protections for private life? Or do you think that the goals are completely incompatible?
Again, a version of Part 1 with appropriate amendments could accomplish some of that, but Part 2 is not necessary and goes well beyond what is helpful.
Monsieur Surgeonor?
Mr. Surgeonor?
I would say that, and I'm no parliamentarian, so the actual process here is somewhat foreign to me, notwithstanding the fact that I too am a lawyer like many present. I would just say that what struck me, and I think I share a similar perspective as that of Mr. Hatfield, what struck me really is the imbalance between the first part of the bill and the second. In fact, I remember communicating with colleagues who are eminently more qualified than I, and yet here I am. And they actually told me they helped shed some light on the fact that the first part of the bill, I think, is what I would expect and want to see from a proposed bill, which is to say a thoughtful and progressive evolution of what it is we're seeking to achieve here, which is law enforcement and bolstering the tools that police have. But I would say that there is a way to do that doesn't require such a leap forward. I think that there's a kind of internal coherence, or at least there should be, in the process, both in making law, but also in investigating crime, where one must lead to two, must lead to three, and so forth. So I'm not particularly convinced that we live in a moment that is any more challenging than any other moment that came before. I think that if you were to rewind the clock to any particular time, people were facing difficulties that were. The difficulties they faced were the difficulties they faced, and the tools.
Sorry to interrupt, Mr. Surgeon. That's always with great regret that I do that. But we now need to turn to Madame de Bellefeuille for 6 minutes, please.
Merci, Monsieur le Président. Alors, d'entrée.
Thank you, Chair. First off, I'd like to agree with Mr. Caputo. I think that around the table, everyone can agree that all parties agreed to collaborate and do a rigorous study without any filibustering, because this merits our attention. But when we were suggested the agenda, we were never told that we would not have the translation services to read the briefs. And that's a bit odd, isn't it, to tell everyone that Canada does not have the means to translate something in 2 weeks, to translate the briefs from the Canadian Bar Association. I think this is unacceptable. I understand we have limited resources, but when we want to rush and study a very important bill like C-22, well, we must have the means. There's a question of priority. Not all committees are studying such an important bill like C-22. I think this is unacceptable and embarrassing. Please understand that I'm a Quebecer, and I want Quebec to be a country, but if I was a Canadian, I would be really embarrassed that Canada does not have the means to translate documents in 2 weeks for such an important bill. Question for you, Madame Saad. You seem to imply, if I understood correctly, you seem to imply that perhaps the bill could be split. So we could adopt the first part and then discuss and redebate on part 2. That seems less acceptable. That has less social license and less approved of by professional associations. So would you be implying that we ought to split the bill so more people can get behind part 1 because part 2 seems to be more problematic? That's exactly one of our recommendations. Given that the subjects are complementary but different, that would be an avenue we recommend. There is a lot of pressure from all of the police associations are writing to us. We're being pressured by them. And the only witnesses that agree with C-22 as it stands are police forces. And as my colleague, Madame Danderand, said, we need to modernize the law and give more tools to police. But it just seems like it's gone so far because almost all witnesses are against it. Like, there are people like Open Media who are completely against it, and there are those who are police on the other end of the spectrum. And here we want to see how we can make it acceptable. And I understand that one way to move forward would be to split the bill, and for part 1, in my opinion, well, I think that part 1 would be passed quickly. In my opinion, I don't have any technological knowledge. You're a lawyer according to the charter and case law, and your worries regarding private life. I always say we want to compare ourselves to other countries, but we don't want to lag behind, but the countries that we're comparing ourselves to aren't good examples. If we compare ourselves with the United States, it's the Wild West. And the UK, it's very intrusive. And so I do not want to be compared to countries that don't necessarily have best practices in protecting private life. This is my question for you, Mr. Hatfield. Can you tell us technically what scares you the most? Because as a bill, we could say, for instance, forbidding going around encryption, forbidding end-to-end encryption. If we put that on paper in black and white, would that be enough for you? So even if we wrote that down as an amendment, would that reassure you?
So it's not strictly necessary to break encryption, and that was a point I was trying to make in my remarks. The concern is that by having the power to install devices into systems, there's many ways in which you can get around encryption without breaking the technical standard. So only by adjusting the order-making power so it could never have the effect of circumventing encryption, that would do some work on that front. Also, we're extremely concerned about this metadata retention requirement. There's just nothing like this in any other comparable democracy, and it needs to go entirely.
Mais là, la rétention de métadonnées.
But here, the metadata retention, well, here we've proposed up to a year, but if there was a suggestion of 90 days, would that be more reassuring for you? Would you be comfortable with 90 days?
We'd not be comfortable. It's still incredibly valuable, incredibly personal data. You know, every person that you've spoken with for 90 days, every place you've gone for 90 days, that's actually an enormous picture of your life. And not only is that a bit concerning to hand to law enforcement, if and when, and it is likely when, that data is compromised, that's a huge amount of personal information in the hands of bad actors and on the dark web, potentially permanently.
Une enquête, ça prend un certain temps.
Well, an investigation takes some time when you're doing an investigation, but at the same time, we want the bad guys to be caught. Don't you think it would be reasonable? Do you really think it's reasonable to say no metadata retention at all?
Well, there's a reason that very few of our allies do this, right? And it's the fact that it's creating, it's constitutionally questionable. It creates a preemptive collection of data on many millions of Canadians at once on every service that is scoped in. We don't normally do surveillance of everyone just in case it proves useful. Normally, the process would be if someone is found to be warranted, there's a warranted crime occurring, then perhaps you might start surveillance. That's how the traditional system works, and that would be a more appropriate system here.
Merci beaucoup, Madame de Bellefeuille.
Thank you very much. And now, Mr. Gill, for 5 minutes.
So first, I just want to start, and this is an open-ended question to everyone, all the witnesses here today. Thank you for being here. But my question is, does this feel rushed to you that we do not have enough time to study part 2? And I would like to question every one of you, and if you could respond to that, please.
Well, I'll respond briefly, and this is one of our conclusions, that there are too many pieces, and the risks are too high for all Canadians and all the parties involved. We recommend more consultations with different stakeholders.
John?
Thank you. Yeah, I would echo that broadly. Again, I don't know what precisely it takes for parliamentarians to achieve what they need to achieve, but my sense in reviewing the bill is that just the sheer scope of words, and now I'm speaking as a former English major, the number of words, and I mean that not in too cute a way, there are so many verbs in this bill: use, access, take. These are not trivial words. They are extraordinarily broad because they just are. And so it's been quite a task reviewing this bill. I've had to review it countless times at this point, and at no point have I been assuaged. Have my worries been assuaged? I think that much more time is needed just to go through some of these basic definitions.
100%. Thank you for that. And Mr. Hatfield, could you please provide a response as well?
Look, this is the most dangerous surveillance bill I've seen in more than 10 years of doing this work in Canada and even in other democracies. It has not gotten nearly enough time. If we had realized that, I guess on a resource limit, our brief was being held up and wouldn't reach you vote before you considered amendments, of course we would have gotten it in your hands by another way sooner. And certainly you need to take more time to assess the weight of evidence here and realize that the weight of evidence is overwhelmingly against Part 2.
Yes, it is quite upsetting to be in quite of a dark hole with not having information that we need that is so crucial to the study. I have one quick question for you, Mr. Hatfield. In an open letter of yours, your company argued that certain aspects of the bill would create an unprecedented and extraordinarily dangerous surveillance architecture that could impact every digital tool people in Canada depend on every single day. So could you please expand on the specific aspects of Bill C-22 do you believe that propose greater risk for Canadians' privacy and cybersecurity acts, and which amendments would you most improve for the proposed framework of this?
So this gets back to the definition of electronic service provider and how enormously open-ended it is. The government has refused to put clear limits on that. The government, of course, can scope folk in as a core service provider for undefined reasons in the future. The baseline definition of electronic service provider includes basically everyone who handles data. And of course, the minister has the power to issue any of the orders requiring any of the features it requires of a core provider, of a non-core provider in the future. So I don't know that we continue to realize just how extraordinarily broad this is in scope. Now, does that mean the minister would abuse it day one? No, not necessarily. But textually having it so broad is very problematic.
Thank you very much. I would like to allocate the rest of the time to my colleague, Roman Barber.
Just to the Canadian Bar Association, to follow up on Mr. Caputa's question on seizure. The issue is not that a third party is holding on to the metadata. It's the fact that it's holding it by virtue of a government order, effectively. Doesn't matter if a school principal is holding on to the contents of a student's locker by virtue of police direction or government direction, that's a seizure. If a gym is holding on to my gym bag because the cops asked it to do, they're an agent of the state, and therefore there's seizure. Am I correct in that respect? Okay, I don't think we can hear you.
Excuse me. Yes.
Thank you.
This
Okay.
is our-
And to follow up, some people are making the argument that there is no production because the metadata never left the internet provider, but the production is in the holding. It's already defined because the service provider is ordered to hold it. So effectively, it's a defined data, defined information. Am I wrong on that?
Well, the problem is not only the holding, but all the risk by holding all this.
I'm not talking about risk. I'm
potential
talking about the law. I'm talking about the fact that by virtue of it being held, defined, filed away, that amounts to the level required to meet a breach of Section 8.
Well, according to our study, yeah.
Okay.
I need
that's
to
that's
check
the
that.
brief
Thank
produced.
you, MP Beber. That was short. Indeed, MP Sodi for 5 minutes, please.
Thank you, Mr. Chair, and thank you to our witnesses for being here today. Ms. Saad, from a legal standpoint, how do you suggest that we can balance the safety and security of Canadians with the concerns that you have raised or the organization has raised?
Can you repeat the question, please?
Of course. So from a legal standpoint, how do you suggest we can strike the right balance between the safety and security of Canadians alongside the concerns that you have raised?
So in our, well, we will receive it eventually, but in our full submission, we propose certain amendments, although we highlight many risks, as I mentioned. But for the section, for part 2 of the bill, it's really problematic, and it needs additional amendments to strike this balance that you are referring to.
Mm-hmm. If you're able to, can you elaborate on some of those amendments, just because we
Sure.
don't have the brief right now?
Let me just get back to the submission. So, for example, so I've mentioned the ministerial orders that we recommend to be struck. For another recommendation is the systemic vulnerability. We recommend an amendment to the definition so we recommend to really focus on the mentioning the encryption part, and as well. So to clearly carve out the encryption, and we recommend, so systemic vulnerability means electronic protection that creates substantial risk of the confidentiality, integrity, availability of information or services. So this is one of the other amendments. We also recommend, so I mentioned the question of the involvement of the electronic service providers, where they are involved without compensation and without holding all the risk. And we also recommend that the minister should have to justify on a per order basis the need for secrecy associated with these orders. So these are some of the recommendations as well. For the inspection powers as well, so we recommend including a threshold that of reasonable and probable ground before designated persons can enter the premises. So we elaborate on some of these, as well as for the audits. So we recommend that so further procedural safeguards to be included. And we also, on several sections in our submission, we highlight the judicial overview and the possibility of appeal as well, and judicial review. So these are some of the recommendations in our submissions.
Okay. Thank you. The CBA's membership also includes a wide variety of people, such as Crown prosecutors, police legal advisors, and counsel that represents lots of different sectors. Do you believe it's fair to say that the CBA might be divided on the question and the topic of lawful access, and how was the association's position on Bill C-22 developed?
So the CBA represents over 40,000 lawyers in all from all different practice areas and from public sector, from private sectors. So all our submissions are also reviewed by policy and policy committees at the CBA. So for this submission, we've worked with the criminal law, the justice section, the privacy and access. So we are not for part one. We were not that divided. We struck consensus.
But you would say that there is a divide?
No. So what I said earlier and what we will see in our submission, we are not divided. This is the opinion of all the sections that worked on the submissions and that the CBA approved as well. So we are talking from one voice.
Okay.
Merci, Madame la députée Sodi.
Thank you. Now, Madame de Bellefeuille for 2.5 minutes. Thank you very much, Mr. Chair. Madame said, so you have pretty much the same opinion as the Quebec Bar Association. It's too bad that we were not able to have your brief for your proposals because the deadline to submit amendments was yesterday. So that's too bad. Mr. Sanjanor, please speak to the other countries. We're only hearing positive things, and some witnesses for the last few weeks have been saying you shouldn't really compare yourselves to other countries because we can't really be compared, because in Canada we have a deep attachment and culture related to our private life and our privacy. So what do you think that other countries are doing that we shouldn't reproduce that are in the bill?
So, Madame, I have to regrettably inform you that I'm not up to speed in the precise contours of what the other, I'll use the phrase Five Eyes, just because that's what it is. It seems that we've heard that from those who have spearheaded this bill, that really we're talking about the Five Eyes. I'm afraid I just don't have the knowledge about what other countries are doing. But with respect to the culture of, culture of privacy, I would suspect that that's something that's shared across the Five Eyes. And I'm just drawing that inference because there's been a robust history of cooperation for many years at this point. But I can't give you a more fulsome answer. I just know that from the Canadian perspective, and I'd like to, again, highlight the nonpartisan character of our organization. Our concern is a general one. It's a concern about the sheer overbreadth of this proposed legislation. If criminals are the ones that need to be targeted, there's a way to do that in a more targeted way. That doesn't appear to be the case with this bill. It seems that far too many people who have absolutely no connection to criminal activity and would be caught up in this. And I think that I can't speak for our Kiwi or Australian or British or American friends, but I suspect that, I would hope that they're not interested in investigating innocent people, but what they're doing precisely, I can't say.
Thank you. Now, Madam Kirkland.
Appreciate the time. I do have a few questions that I'd like to ask all three witnesses, and more than likely they will just require yes and no answers, unless there's something very important that you feel like you need to add do let me know. Throughout the study, we've heard department officials and even the Minister of Public Safety repeatedly say that Bill C-22 is encryption neutral. That was the word he used, and does not create backdoors. Having reviewed the legislation, do you believe those assurances are fully reflected in the text of the bill itself, Mr. Hatfield?
There's no such thing as encryption neutral, and this would damage encryption's purpose very severely.
Thank you, Ms. Siad.
No, we don't. They're not.
Not. Mr. Surgeon?
I'm sorry, could you pose the question again?
Having reviewed the legislation, do you believe the assurances that Bill C-22 is encryption neutral are fully reflected in the text of the bill?
It's hard not to be cynical as a lawyer. I don't really believe many assurances from anyone because I can't even trust myself most of the time. No, I think that it's quite clear that what's outlined is a not so.
So not clear, it sounds like.
No, let me clarify. My apologies. I just mean no. The answer to the question is no.
Okay.
It seems like the aim here is to create a path to access.
Okay.
And
that answers my question. Thank you. Again, to all three of you, do you believe there's a clear difference between what the minister says a bill is intended to do and what the bill would legally allow or permit a future government to do?
Yes, very much so. Intentions don't matter, and what the text does here is well beyond what the minister has said the purpose is.
Thank you. Ms. Han?
We agree.
You agree?
Yeah.
Mr. Surgeon?
yes, agreed. And I appreciate Mr. Hadfield's comment about subsequent, or the question rather, with respect
subsequent governments.
Exactly, because legislation, if not repealed or amended, does tend to take on a life of its own after a time, and maybe the original purpose is forgotten or muddled over time, so that's a concern.
Wonderful, thank you. So then would you agree with this is the conclusion I'm coming to, and I would like to see if you would agree with me. With Bill C-22, the Liberal government is selling Canadians a privacy promise that actual legislation doesn't deliver, as it is written today.
Yes, agreed. If anything, I'd be stronger than that.
Fair?
Raise it this way, but we have serious concerns in terms of privacy.
Thank you.
I'm sorry if the question could be asked again.
Yeah, no problem. Maybe I should go to you first next time. It feels like we're being sold a privacy promise that the actual legislation doesn't deliver. Would you agree?
I don't know about the word promise. I just have an issue with the legislation as it currently exists, because I think, as I've said repeatedly, it's too broad, and there are too many entry points.
Mm-hmm. I think you've all said you agree that things are too rushed. We've barely had time to absorb pieces of this bill, let alone all of it. I have significant concerns about that. I've said that many times. Rushing a bill is not doing it justice and could cause a great deal of harm. Mr. Surgener, you talked about metadata being information about information that is preserved for review. And I appreciate that, because I don't know if Canadians really understand what metadata is. And so if you could clarify what it is, information about information, and why storing metadata could be harmful if it's for every Canadian.
Yes, happy to. My understanding is that...
Your mic, sorry, is not on. We'll just wait.
Pardon me. Can we heard?
Oh, there you go.
Oh, thank you. Yes, that is the position that we have, that metadata is information about information, and it took some time to wrap my head around that, because you're quite right, it's not exactly clear, and it's kind of a thin veneer, the language of the bill, I mean, because as I read it, it's not a great leap to learn, for instance, that device X was communicating with device Y, even if the content of the communication isn't clear, especially given the fact that all sorts of related information is also up for grabs. So it wouldn't be very... Presumably, this is the point of the investigative powers, is to gather as much as necessary to positively identify an individual, particularly to echo Madame Sad's comment, when we talk about the definition of subscriber information. So taken together, you have a constellation of information, and that's what the metadata is. Device X talking to device Y, and if that's being held onto for up to a year, it's actually difficult to grasp and comprehend how much communication is caught by that, and so it's an important point.
Merci.
Thank you.
Désolé, Madame la députée.
Thank you.
Thank you.
Pour 5 minutes, s'il vous plaît.
May I raise a point of order at this point, please, Mr. Chair?
Yes, Mr. Caputo.
Thank you. I know I didn't know when the rounds were going to be cut off, so I said I would do it when Ms. Kirkland was done. So I don't, if Mr. Housefather wants his time afterwards, go ahead. But we have not yet received a ruling from the chair on Mr. Lloyd's point of privilege. I know that you did circulate an email, which was not from the chair, so we haven't had that yet. Given what we are dealing with now, somebody has contacted my office and said their brief also hasn't been translated, submitted 8 days ago, if we take them at their word, which I'm obviously prepared to. And Mr. Lloyd raised a point of privilege. So I wonder if at the end of Mr. Housefather's round, if you could please advise us on that point, because we do need a ruling on that. If there is no ruling, I would be prepared to revive that point of privilege and add my voice to it, given what we've heard today. Thank you.
Thank you, Mme Caputo. Monsieur le député Housefather, pour 5 minutes, s'il vous plaît.
Merci, Monsieur le Président. Je partie de mon temps avec Monsieur Ramsey.
Thank you, Chair, and I will share part of my time with Mr. Ramsey. I'd like to find a solution for the problem that was brought up by Mr. Caputo. I have a question. Do I understand correctly that you submitted your brief in French and in English? Yes? Yes, that is correct. Mr. Chair, the interpreter respectfully requests to not open cans in front of the microphone, please. I would ask that the Canadian Bar Association's brief, as well as all the other briefs that were sent in the both official languages, even if they have not been authenticated by the Translation Bureau, be sent to the committee. That depends upon the committee. We will need to have unanimous consent because the regulation from the beginning of the session are very clear. It is possible. But quickly, let's see if there's unanimous consent. Madame de Bellefeuille, having a hard time with the precedents. I understand what Mr. Housefather is trying to do, but as you already sent it in both official languages, perhaps you could send it to us individually, to the members of the committee. Because I don't want us to create a precedent by accepting copies that have not been authenticated by the Translation Bureau. But if you were to send us an email to all those of us and say, all those that have been sent in both official languages, I cannot accept that because that's creating a serious precedent. And I'm not able to evaluate if I have something that's properly translated. I understand that if we were all Anglophones, it would be easy because it would all just be in one language. But I understand Mr. Housefather's intention. And for you, I'm not worried that your versions will be of poor quality. I often tell our witnesses, because of the Translation Bureau's limits, which is, in my opinion, is completely unacceptable, sometimes we need to collaborate with witnesses that are very credible and that send us their briefs in both official languages. So, Mr. Housefather, I hope you understand that I cannot agree because it will create a precedent. All right. In that case, what we can do, based on Madame de Bellefeuille's proposal, is that the organizations like the Canadian Bar Association that would like for their briefs to be accessible faster will send it directly to the MPs. You can easily find their email addresses on the House of Commons website. And the MPs can do as they see fit with those briefs. They're in French and in English, but we cannot prevent an organization from sending a brief to MPs. It would obviously be good if it was in both official languages, and the MPs can act at their discretion. Madame de Bellefeuille, as we're taking some time for this, and it's a very important subject, you, as the chair, if everyone agrees, could you write to the Translation Bureau, to Mr. Limburner, to say that this is unacceptable and that we expect when we undertake such an important study like this one on C-22, that our priority be taken into account. And it doesn't make any sense for us to not have a brief from the Canadian Bar Association in a bill that's on legal access. It's totally illogical. That said, you, as a chair, could you make an official complaint? Because this is a situation that is unacceptable. Instead of accepting it, well, we have to speak up, because often you said, when you said, we're not the only committee, these are the limits. That's not what I want to hear from my committee chair. I want a committee chair that defends us, that says we want to do our work and you're not giving us the necessary tools to do our work. That's what I expect of my committee chair. Not someone who's going to give up, but someone who's going to fight for having services. Well, first thing, I will share your point of view and defend the interests of this committee. And the second thing that the chair will do is a pedagogical exercise. A few minutes ago, I received information regarding the brief from the Canadian Bar Association. This brief was submitted May 29th in its entirety, with the number of pages that surpassed the number of pages that was communicated. The final number of pages only arrived June 1st. So even with many resources at our disposal, it is hard to work with that time. That's an important pedagogical exercise. It's important to understand in committee relationships, in the relationship between the committee, and the House of Commons. That said, I will communicate that with pleasure, and we'll see what happens. And so now I will give Mr. Housefather his time. I think that I probably took up all that 5 minutes, but I will give the rest of my time to Mr. Ramsey. Thank you. I completely understand my colleagues' hesitations, but I just think it's so important for us to do the clause by clause. And if we had their brief in 2 official languages, it should not take so long to ensure the quality. It's not the same as translating the whole brief. And I really hope that they can at least do that.
Hear that in English. If you have your brief and you want us to see it before, send it to us directly then on our emails. It's the same first name dot last name at parle.gc.ca, and at least we'll have the choice then to read it, if you send it. Thanks, Mr. Chair. Sorry, Jacques.
Mr. Surgeon, I just want to come back on something you said. I would put it on your age. You look like a bright fellow, but it was quite naive, really. If you want to say that the challenges of law enforcement are the same they are today than they were a long time ago, when they only had to look into the white pages and find the information they needed. It is no more like this. And all the police chief force from all over Canada, it all spoke with one voice to say that they really need a lawful access regime because it was needed. Madame Saad, permettez, je peux parler en français? Madame Saad?
Madame Saad, I will speak in French. You said that they already have the means at their disposal, that is, of the police. You're right, but perhaps you didn't read the title of Part 1, Timely Access. That's what the police are telling us, that their investigations are lagging, and they don't have enough time to access information. There are too many obstacles. So I'd like to tell you that it's timely access.
Monsieur Hatfield, vous avez dit que
Mr. Hatfield, you said the government is going to open up spyware and microphones all over in people's homes. That is not the case, perhaps with the caveat that Mr. Baber brought up. The government needs legal authorization to acquire information that we're asking companies to keep are not accessible to the government unless they fulfill the conditions, that is, suspicion that some information will lead to a conclusion that will bring about a legal conclusion. Yes, unfortunately, that is your time. And before suspending, on the question of the point of privilege. Yes, I communicated with 3 different parties. I shared the considerations that I collected over the last few weeks, and I saw there was a violation of the MPs given the circumstances, which leads me to thank you, our 3 witnesses, for your appearance, and for everyone else, we will suspend for a few moments.